John, gotcha. John A. Birmingham Jr. Esquire is a licensed attorney in New Jersey who has over 17 years of experience as an in-house counsel and is currently Associate General Counsel at Breckenridge Pharmaceutical Inc., where he handles corporate law, transactional matters, business law matters, and contract law. Attorney Birmingham is admitted to practice in the United States Supreme Court, the Supreme Court of New Jersey, and all other state courts of New Jersey, and admitted to the District Court for the Federal District of New Jersey. Attorney Birmingham is a professor where he teaches constitutional law, government law, business law, and various health law classes, among others, for Purdue University, St. Leo University, Centenary University, and Southern New Hampshire University. Professor Birmingham received his Bachelor's of Science in Justice Studies at Arizona State University, his MBA with a concentration in criminal justice at St. Leo University, and his Juris Doctor at Catholic University in Washington, D.C. Furthermore, John Birmingham was elected by the people of Upper Mount Bethel, Pennsylvania, in the November 2015 general election to the Board of Supervisors and has been a supervisor since 2016. John was reelected to the Board of Supervisors in 2022, where he will serve until 2027. Please join me in welcoming John A. Birmingham Jr. Esquire as our presenter today.
Thank you, Elena, and good to see you again. Good to see everyone again. Honored to be here. And we are doing part two of the Fifth and 14th Amendment. So I'm going to share my screen and let me know if you can see the PowerPoint. Um,
That's it.
Great, thanks.
Mhm.
So I know last time when we met, we were in the Fifth Amendment and we were finishing up right around the Miranda warnings. Um, so I'm going to continue from here, and then we'll get into a little bit of eminent domain. I'll briefly touch over the 14th Amendment, and then we'll get into due process because due process is part of the Fifth Amendment and the 14th Amendment. Just a question to ask everyone, and feel free to unmute yourselves or go into the chat room. But I just said the due process clause. We have a due process clause in the Fifth Amendment and the 14th Amendment. My question is, why do we have due process in the Fifth Amendment and the 14th Amendment? Why is it in two different amendments to the U.S. Constitution? And feel free to chime in. It's okay if you don't know the answer. That's what this training is all about, and seminar and webinar or whatever we call it. But that's my question, and I will give you a quick disclaimer before I move on uh, anymore. My wife and I have two young boys, 5 and 9. They are off school. Um, my 5-year-old is upstairs right now. 9-year-old will be home soon. I told our 5-year-old, I said, I'm going to, so he could understand what I'm doing. I said, I'm going to kind of teach a class. And I said, if it's an emergency, you can come and get me. I said, if it's not an emergency, just wait until my class is over. And right before I signed on with Elena, I hear from upstairs, it's an emergency. And I said, Michael, what's the emergency? And he said, well, I need animal crackers. And I said, well, I don't think you really understand the definition of an emergency, or maybe that's my fault because I didn't give him any examples of what an emergency is. So that's my disclaimer. Hopefully, there'll be no more um, non-emergencies getting classified as an emergency. But getting back to my question, I'm going to talk about the due process clause in the Fifth Amendment and the 14th Amendment. Why do we have due process in both the Fifth and the 14th? Let me see. That's right, Karen. That's exactly right. Um, But why have a Fifth Amendment in the why have a Fifth Amendment due process clause and a 14th Amendment due process clause? Anybody want to take a guess at it? And I promise I won't call on anyone. Okay, no one wants to take the step forward. That's okay. So, oh, Jacqueline, good job. Did the 14th clarify the fifth? Somewhat, yeah. And I'm glad you brought that up. That's a good point, Jacqueline. So the original Bill of Rights, the first 10 amendments, when the Bill of Rights were 1791, when they were first drafted and ratified to be part of the Constitution. Constitution was written in 1787. Bill of Rights came along 4 years later. And the reason for that is that the Bill of Rights, the first 10 amendments, were put in place as restrictions upon the federal government because you had the Federalists and the Anti Federalists. The Federalists were for a strong central federal government, where the Anti Federalists were more about state rights and were in fear that having a federal government would lead to the same type of ruling power that Great Britain had over the colonists. So the first 10 amendments were solely limited to the federal government. Then we had a Fifth Amendment due process. Um, yeah, thanks, Lavelle. And good point. So Fifth Amendment due process clause only applied to the federal government, but the 14th Amendment, which was written and put in place after the Civil War ended, um, wanted to make sure that states were also required to follow due process. Because the Fifth Amendment only applied to the federal government. But the 14th Amendment made sure that due process applied to the states as well. And the 14th Amendment also has what's called an incorporation doctrine, which means the first 10 amendments through the 14th Amendment now apply to the state governments. So that's why you have a due process clause in the Fifth Amendment and the 14th Amendment. Fifth Amendment applies originally applied to the federal government only. The 14th Amendment due process clause now applies to the state. So, like Jacqueline said, it kind of clarified the fifth that um, under the incorporation doctrine, we're going to make sure that the Bill of Rights also apply to the states as well. So we'll get into that a little, but let me take a step back and let's finish up on the Miranda warnings. The Miranda warnings, as you all know, you have a right to remain silent. You have a right to an attorney. If you cannot afford one, one will be provided for you. If you do speak up, just know that anything you say can and will be used against you in a court of law. Now, the Fifth Amendment has a self-incrimination clause, right? That says you cannot be compelled to be a witness against yourself. But what does that mean? We don't know what that means, right? That you can't be a witness against yourself. So the Supreme Court in the 60s said, well, let's have these Miranda warnings that kind of fully explain what the self-incrimination clause means, because that's only fair under due process. So the Fifth and 14th Amendment, that those accused of a criminal act or may say something incriminatory know that they have the self-incrimination clause, that they can remain silent. And you know what? Let's go even farther and tell them if they want an attorney, they can have an attorney. And if they can't afford one in criminal cases, they'll be provided one by the state. So that's why we have the Miranda warnings. And the question to think about is whether Miranda warnings are fair protections to suspects. And what I mean by fair is when you have a suspect means that you don't have enough evidence yet, but you've got a hunch that this individual may know something about the criminal activity. But police, even before they can question the individual, have to tell them about these Miranda warnings. That you don't even have to talk to me as a police, even though I'm a police officer. You can say no to my questions. You can say, I want an attorney right now, and I, as a police officer, have to stop questioning you until you get an attorney. Um, does that harm investigations where the police can't just immediately question someone if the police believe by my question this individual may make a self-incriminatory statement? I've got to read this individual the Miranda warnings or give them the Miranda warnings um, before I go on questioning the individual. So feel free to share your thoughts on that, but something to think about whether Miranda warnings are fair protections to suspects. And here's a little bit more. Elena, I think I shared these slides with you. Um,
Yes.
okay, thanks. So
Okay.
you may have seen these slides by looking through them. Now, our legislature at times throughout our history has said the Miranda warnings are not fair, and they have tried to reverse or stop the Miranda warnings from being read by police officers when questioning an individual. Um, the congressional anger at the Miranda decision led Congress to pass a law in 1968 that basically restored voluntariness as a test for admitting confessions in federal court. That if the individual basically wanted to volunteer the information, that the Miranda warnings did not have to be read. The individual says, hey, I want to come clean. I want to tell you what happened. I want to tell you what I did. The police don't have to say, hey, before you do that, let me read you the Miranda warnings. Congress basically said, um, that if the individual wants to voluntarily talk to the police officers, no Miranda warnings have to be read. Supreme Court said that, hey, Miranda's based off Fifth Amendment principles such as due process, the self-incrimination clause. Therefore, Congress cannot overturn a Supreme Court ruling, such as Miranda v. Arizona. So Congress has tried to limit when police officers have to give the Miranda warnings, but the Supreme Court has shut it down, saying that it cannot be overturned legislatively. Let me know if you have questions on that. In 2002, Chavez v. Martinez, Supreme Court said a police officer does not deprive a suspect of constitutional rights by failing to issue a Miranda warning. So let me talk about this case, because usually here, hey, if the individual didn't get his Miranda warnings read to him, that confession has to be thrown out. But in 2002, in Chavez v. Martinez, the court said if the officer fails to give Miranda warnings, we're not going to throw out the confession automatically. So what happened in this case, Martinez gets shot. He's been treated for gunshot wounds during a fight. and he's being interrogated by Chavez, who's his patrol supervisor. So Martinez said that during the interrogation, he used heroin and had taken an officer's gun during the incident. And at no time during this interrogation was Martinez given the Miranda warnings. He was charged with the crime, but his answers during the interrogation were never used against him again in any criminal proceeding. But Martinez goes on and wants to challenge it. Um, he's trying to get this the Supreme Court, to rule on what the patrol supervisor had done. Right, so Chavez interrogates him why he's being treated for gunshot wounds, wants to know what happened, why he got shot, and never gives him the Miranda warnings. He's a patrol supervisor, right? He's not a police officer, but he's a patrol supervisor, so he does have some authority under state law. So Martinez files suit saying that Chavez's interrogation violated the self-incrimination clause, and that his 14th Amendment due process right to be free from coercive questioning was in violation of the Constitution. Supreme Court comes back and says that the text of the self-incrimination clause cannot support the view that the use of compulsive questioning or interrogation without more violates the Constitution. So where the Miranda's warnings go in the future, I mean, this is a 20-year-old case, a little more than 20-year-old case, but it kind of gives a little more leniency to police officers and even patrol supervisors, saying if they are trying to find out what happened, not knowing whether a statement is self-incriminatory or not, that just questioning, right, without more violates the self-incrimination clause of the Constitution. So anytime a police officer goes up and questions someone, if the police officer believes the individual's response to the police officer's question may be self-incriminatory, the police officer has to give the individual the Miranda warnings. But if the police officer is just questioning an individual, like what happened here, or what's going on, or who's hurt, is someone in the house hurt, not knowing whether a self-incriminatory statement is going to be given by the individual, does not violate self-incrimination clause of the Constitution. Police officer has to believe that the response by the individual may be self-incriminatory, and therefore the Miranda warnings have to be read. Bergwis v. Tompkins, 2010, 8 years later, criminal suspects who are aware of their right to silence and to an attorney, but choose not to unambiguously invoke them, meaning their Miranda warnings, may find any subsequent voluntary statements treated as an implied waiver of their rights. So if an individual doesn't come out and say, yeah, I want an attorney, I'm going to remain silent, I'm not talking to you, but kind of, yeah, I'll talk to you, I'll give you some information, but I'm not going to help you in every aspect, and doesn't fully state out, I'm invoking my Miranda warnings, I want an attorney, doesn't flat come out and say that any other subsequent voluntary statements may mean this individual waived his Miranda warnings. Let me know if you have questions on that. I'll check the chat. Oh, Karen, let's see. Karen, it's a great question. Karen's question is, would they have to amend the Constitution to change the law if Congress cannot make that change? It's a great question. Unless Congress could find a way, could almost find a loophole in a sense. I mean, that, you know, you're kind of, Congress could write a law right here. I mean, you got a Supreme Court decision, right? But you know, the Supreme Court can always overturn itself, as it did in Roe v. Wade, right? So this could always be overturned. But if Congress put a law in that basically says individuals who choose not to unambiguously invoke their Miranda warnings may find subsequent voluntary, Congress could write that into a law without amending the Constitution. Or same with this one. The mere use of compulsive questioning without more violates the Constitution, or does not violate the Constitution. So compulsive questioning does not violate the Constitution. Congress could put that into a law. But if Congress wanted to, like in the Dickerson case, say voluntariness is the test for admitting confessions in federal court, well, they can't write a law on this, and they would have to do an amendment because the Supreme Court has already ruled. Unless the Supreme Court looks at it again and says, okay, we're going to now make voluntariness as a test for admitting confessions in court. So great question, Karen. The amendment process would be the easiest to get around the Supreme Court, but as you know, the amendment process is difficult to do unless they found some other sort of loophole that wasn't exactly the same as the Dickerson case or the congressional law that was at heart of the Dickerson case. They could do it that way, but yeah, most likely an amendment would be the way to go about it if they wanted to, in a sense, try and overrule the Supreme Court's ruling in Dickerson. Great question. That was my long answer.
Thank you. Yeah, it's a little bit confusing because I read that rule someplace else recently that Congress could not make a law that was in contradiction to the Constitution, which makes sense on the face of it. But you know, when you're thinking about like the checks and balances between the three branches of government, I was thinking at the time that Congress kind of was the check for the Supreme Court. You know, they could change a law, but apparently not.
Yeah, and you know, the Supreme Court, the judicial branch's role is to interpret the laws. But as you know, throughout rulings in the history of the Supreme Court, they can change their interpretation of what the law means, right? I mean, Plessy v. Ferguson, separate but equal, meant one thing at the end of the 1800s, but in 1954, with Brown v. Board of Education, separate but equal meant an entirely different thing. So, as Supreme Court justices change and the makeup of the court changes, interpretations change. So, the Supreme Court can always come back and overrule itself as society changes, as public opinion changes. But yeah, I mean, it is correct. Congress cannot write a law that violates the Constitution, but the Supreme Court can always interpret a congressional law as violating the Constitution or not violating the Constitution when it comes in that gray area. Does that make sense?
Yes, thank you very much. I appreciate it.
Thanks, Karen. I'm still stuck on Congress not being able to pass a law. Yeah, I mean, it's a good point, but the bottom line is, if Congress is violating the Constitution, it's the Supreme Court's role to strike it down. You know, Congress can't just pass a law that is clearly in deprivation of due process rights. Congress can pass a law, and whatever law it wants, someone has to challenge that law, and the Supreme Court has to be willing to hear that case. So it's a good point. Congress is able to pass a law, and that law can go into effect if the president signs it, or an exception applies. So Congress can pass a law, but until someone challenges that law and it works its way through the court system, the Supreme Court can strike it down or not strike it down, depending whether it's a constitutional violation or not. Hope that clarified. Okay, thanks. All right, so that's the Miranda warnings where I wanted to finish up. Eminent domain is also part of the Fifth Amendment. Eminent domain basically is the power for the government, or if the government delegates that power, it gives government the power to take private property for public use. And it can be either the state, it can be a local municipality, or the state or municipality can delegate it to a private person or corporation. And that private person or corporation or the state or municipality has to exercise functions of public character. And if they take property, they have to pay just compensation to the owner of that property. It's kind of vague, right? You know, what is just compensation? I may say my home's worth $10 million in my heart, because I've got all my memories here, where the government say, Birmingham, your home is worth $150,000. And I may be angered by that response. But just compensation typically is fair market value of the home. It doesn't take in, well, Birmingham's lived there as a kid. Now he's a parent. He's inherited the home. He's kept the home his entire life, living there as a kid. Then when his parents passed away, they gave him the home, and he still has it today. They don't take that into account. It's basically fair market value of the property. And just compensation is litigated all the time. What is fair market value? How did you come up with the formula? But that's what eminent domain is. Eminent domain says the government can take private property if it's going to be for public use, because it benefits the community as a whole.
Professor Birmingham,
Yes.
I was just going to ask, do you remember a few years ago, there was a case where there was a Native American tribe that was trying to protect water rights or access to water. And there was a large oil company that wanted to put a pipeline through that area. This was right around the time of the election, right before the election of Trump. I was kind of wondering if you had any thoughts on that.
I'm trying to remember the actual case. I remember something familiar. It's even something I'm dealing with here in my township in Upper Mount Bethel, where I am a local politician. But it's you get into a whole different thing when you're dealing with a Native American tribe because they have protected land federally, and it's a whole different issue. But we are have a developer here in town that's looking to develop, but I'm in the Delaware Water Gap, and there's protective land here for Native Americans, and it's protected a lot more. It's a lot more difficult for the government to do. And in many cases, the government's not going to be able to do it. Um, my thoughts on the case are um, I would do everything to respect the Native Americans and their protected land. Um, that's what I'm saying. I don't remember the ins and outs of the case, but
I
there has to be, I would hope, another way the oil company could get around it. Um, and I'm sure there are other ways to do it. It might cost the oil company a lot more money, and that's why they don't want to do it. But when you're dealing with religious sacred ground and protected land of Native Americans, I think you've got to respect that. But good question, good points, Karen, as always.
Yeah, and just real briefly, I remember the Trump administration granted the oil company the rights to go ahead and put the pipeline through that land. And then after Biden was elected, he rescinded that order and changed it. And I think the oil company decided not to go forward with the pipeline, if I'm remembering correctly. I wish I could remember the name of the case, but thank you so much for the digression.
Yeah, sure. And send me the case if you remember it, Karen, please.
Oh, thank you.
Um, yeah, and I think, that's the power of the people, regardless of what the Trump administration did or the Biden administration did. When you've got the power of the people speaking out against the oil company doing this, the oil company doesn't want bad press, and it doesn't want to get, say, a bad reputation. So, um, I'm sure that was part of the reasons why they pulled out and decided not to go forward. Um, yeah, and I can't, I don't know the ins and outs, so I can't say whether I agreed or disagreed with the Trump administration or with the Biden administration, but um, yeah, it yeah, I'd have to look into that more. Um, so the government gets its power under Fifth Amendment, eminent domain clause. They get it, they have the power through the 10th Amendment of the police power. So the state have police powers under the 10th Amendment. And that's basically to make laws to regulate for the general welfare, health, and safety of its citizens. An eminent domain is taking private property that's going to be for public use. There are a variety of property rights that are subject to eminent domain, and that can even be air, water, and like we've been talking about, land rights. But air and water also come into eminent domain proceedings from time to time. The proceeding is called a condemnation proceeding. That's where there's a whole hearing. The government presents its evidence of why eminent domain should be granted. The landowners or water rights will present their side of the case. Government shows how it's for public use. Government shows how just compensation was arrived at. and the landowners argue their case why eminent domain should not be granted. If it goes to court, government may go to a home and say, Birmingham, we're going to take your land and put it to public use because we want to put we want train tracks to go right through your property because it's going to help everyone to get from the Delaware Water Gap to New York City. We're putting railroad tracks up and down the East Coast for easier commutes into New York City, and the railroad has to come through your property. So we're taking your home. Fair market value right now is 400,000 more than what your home is worth, and we're going to give you that 400,000 more. And I say, fantastic, take it, it's yours. I was thinking of moving into a much smaller home. We're good. The property's yours, local government. So sometimes homeowners can make out with just compensation. Other times they don't, or they don't want just compensation because of it's their home and that's where they live. But during the whole condemnation proceedings, the property owner has the right to due process. Many times government will take the power of eminent domain to take blighted properties. When government takes unblighted properties, blighted means the property is in disarray. It's old, it's not being upkept, it's not upkept well, for lack of a better word. That the property is falling apart. You know, you'll see old buildings where walls are crumbling, maybe the roof's caving in. That's blighted property and much easier for the government to exercise eminent domain. But when a property is unblighted, in good condition, maybe beautiful, beautiful piece of property, beautiful home, and the government wants to take it, the government's going to have more of a challenge showing that the development benefits the entire community. Let me see if there's any questions. Lynn, eminent domain happened a lot in New Orleans after Hurricane Katrina. It was done to build temporary gates, new pumping stations. Yeah, and that's a good point, Lynn. Yeah, I mean, you're talking about the state of Louisiana that was devastated after Katrina, and everything that the government, the state government and local governments had to do to make sure something like Katrina wouldn't happen again. What kind of preventative measures could the state of Louisiana take to better protect themselves? So much easier for them to claim eminent domain, knowing what happened from Katrina, how many lives were lost, and making sure there was any way to stop a water surge like that coming in again. Good example. Okay, so landmark Supreme Court case under eminent domain is Kelo v. City of New London, Connecticut. And this happened in 2000. New London's going through an economic decline. The local government there approved an economic development plan that was going to create jobs and expand the city's tax base. It called for the conversion of a closed naval base and adjoining 115 private homes that were part of an urban village. The city bought 100 of the affected properties, but could not reach an agreement with the remaining owners. So then it decided to use eminent domain to condemn the 15 remaining properties. So the property owners of the 15 remaining homes filed the lawsuit saying that the taking of the city of New London over these private homes violated the public use provisions of eminent domain under the Fifth Amendment. And it was started out at the trial court that ruled for the property owners, was reversed by the Supreme Court of Connecticut that said the taking was valid under state statutes because it was part of an economic development plan to bring more tax revenue to the city of New London. Supreme Court affirmed the state Supreme Court of Connecticut's ruling, and they said that the government can take property from one private individual and transfer it to another private individual if that taking is for private use. So the city of New London basically delegated the power to a developer who was going to build a Pfizer plant. The pharmaceutical company Pfizer was going to build a plant in the city of New London. The developer was given eminent domain power by the city of New London. So the developer is considered a private person. The homeowners are private people. And now you're having one private individual take the land of another private individual. And Supreme Court said this is fine as long as it's for public use. And the public use was Pfizer's going to come in, they're going to have a manufacturing plant, it's going to create all these jobs. There's a lot of tax revenue that's going to the city of New London, so it is benefiting the public. The property owners came back again and said, this taking for economic development should only be allowed if there's reasonable certainty that the city would receive the expected public benefits, like the jobs, like the tax revenue. But we don't know. Pfizer comes in, and if nobody wants to work at Pfizer, there's really no economic development. And what are the taxes that Pfizer are actually going to pay to the city of New London? Are they going to pay a reasonable amount? Are they going to pay any amount? I mean, there's tax breaks that you can give new businesses when they come into a town. In our town, it's called LRTA, which is like a tax incentive or a tax break incentive for new businesses, where they don't pay any tax the first year, and then it goes up in increments by 10% each year till they're at a full 100%. So that's some of what the private homeowners are arguing. That there's no reasonable certainty that this is going to be a successful plan. It's kind of it's a good argument, it's somewhat of a stretch, but it's what you got to argue when you're trying to represent your client. The Supreme Court came back to the homeowner's argument and said that reasonable certainty is too high of a standard, and it would harm all economic development plans. But the court did say its ruling did not prohibit states from passing laws to limit government rights to take property. So the city of New London could write a law that says there has to be somewhat of a certainty that the city would receive the expected public benefit. So the Supreme Court said here that reasonable certainty is too high of a standard. The city of New London wants to write a law that's not as high of a standard as reasonable certainty and maybe make it somewhat certainty, or you know what I'm saying, try to give less of a standard, then maybe the Supreme Court upholds it.
Would that be reasonable possibility, perhaps?
That's a good word. Possibility. I like that. Possibility is less than certainty because you have to be somewhat certain that the city is going to get the expected public benefits, and it has to be a reasonable certainty. But a reasonable possibility, I think, is it's creative wording. So I like it, Karen.
Thank you. Appreciate it.
Yep. Okay, so here are the elements of eminent domain. Government must prove the 4 elements are present. It has to be private property. It must be taken. Can't just take property and not do anything with it. It has to be taken for public use, and there has to be just compensation. But all of these elements are interpreted broadly. I'm going to let you look at the slides to go through all the elements because I didn't realize I'm running out of time again. And, but you can look through these elements, how the court looks at what private property is. What's interesting is that the rifle that was used to kill President Kennedy was considered private property in an eminent domain proceeding because it was a historic artifact and the public would benefit by having access to it. So private property is not just land, right? It's how do you define private property? A taking is what is the government actually taking, right? And that's been interpreted by the court throughout the years. Public use, what is the public use? How is the public benefiting? Is it a reasonable certainty, or is it a reasonable possibility that something is going to benefit the public? And what is just compensation? Like I was saying, the most heavily challenged element of eminent domain is just compensation, because there's no set formula of how the government arrives at just compensation. Let me see if there's any comments in the chat area. Okay, 14th Amendment. Here's all of the 14th Amendment, everything that's in it. And this is kind of what I was talking about earlier in the term, the incorporation doctrine. Basically set out incorporation doctrine as part of the 14th Amendment due process clause that says everything in the Bill of Rights are now going to apply to the state governments. And that's what the incorporation doctrine is all about. Due process clause of the 14th Amendment applies specifically to the states, and it has been used in many cases, like Brown v. Board of Education, which overruled Plessy v. Ferguson and the separate but equal doctrine. Basically, Plessy v. Ferguson said, I think it was 1896, that we can separate African Americans from Caucasians in separate train cars. You can keep them separate if the train cars are equal in their upkeep. If the train cars are both upkept in a similar fashion, then it's constitutionally permitted to put African Americans in one train car, Caucasians in another train car. 50 years later, in Brown v. Board of Education, the Supreme Court said separate but equal is not constitutional, because although you're segregating the populations, the schools for the African American children are not being upkept at the same standard as the Caucasian kids in their schools. So it's separate but equal isn't working. We got to desegregate, forget separate but equal, desegregate the races and put all the children, regardless of their race, in the same school, because that's the only way to keep it fair. That's the 14th Amendment due process clause. Roe v. Wade, 71, 72, basically said under due process clause of the 14th Amendment that state governments cannot invade a woman's right to privacy by understanding if the woman wants to terminate her pregnancy or not, that a woman has a right to choose. The Dobbs case, which recently came out, overturned Roe v. Wade and basically said the Supreme Court in Roe v. Wade read too much into the due process clause of the 14th Amendment and how they interpreted it. And really, Roe v. Wade should be overturned because the Supreme Court, in a sense, legislated from the bench. And this is really a state issue. So we're going to give it back to the states and let the states decide what they want to do about a woman's right to choose or not to choose. Gay marriage is a Supreme Court ruling also under the 14th Amendment due process clause that basically said states who do not allow marriage between a man and a man or a woman and a woman are violating the 14th Amendment due process clause and the equal protection clause, which basically the equal protection clause of the 14th Amendment says that states, local governments cannot write a law that treats individuals in a dissimilar fashion, that under equal protection, similar people in similar situations have to be treated similarly. That's the equal protection clause of the 14th Amendment. Let me just talk briefly about due process. And, somewhere, if you want to have me back again in a few months, I can do a lecture about due process, because this I should spend a lot more time on, and we've only got a few minutes left. But due process, whether you're talking about the Fifth Amendment or the 14th Amendment, due process really consists of procedural due process and substantive due process. And I could do a whole lecture on that, because there are two kinds of due process. Procedural due process basically ensures fundamental fairness, meaning that a party has a right to be heard, especially in an eminent domain case or a criminal proceeding. So procedural due process means throughout the criminal trial process, those accused of criminal acts have to be treated fairly and similarly all along the way. And you even see due process playing a role in eminent domain. If you're going to take my private property, you've got to give me notice. You have to give me a chance to be heard. You have to give me just compensation. you've got to satisfy those 4 elements of eminent domain. Where substantive due process is where the Supreme Court comes in and says, we're making a ruling based off substantive due process because this case needs to protect rights that are so fundamental as to be implicit in the concept of ordered liberty. So procedural due process, the procedures must be fair. Substantive due process is that this right is so fundamental under due process, we need to rule this way because this fundamental right is implicit in the concept of ordered liberty. We'll talk about substantive due process and procedural due process at a different time during a different lecture. But I will leave it at that. I want to thank everyone for attending. Thank you, DAPA, for having me back. As always, honored to be here. I do connect and network through LinkedIn, through Facebook. I would never thought Facebook would be for networking, but I do it. I've actually received many legal cases through Facebook by people reaching out to me. So if you want to connect with me through LinkedIn and Facebook, feel free. That's my email address. Yes, AOL still exists, and I'm sticking with it. And that's my cell phone number. If you ever have any questions or want to talk about something, feel free to call me anytime. I'll open it up for questions. Thank you so much for having me. Take care. Happy New Year.
Oh, thank you so much, Mr. Birmingham. I appreciate you talking to us again. And yes, I will be reaching out to you regarding that due process presentation.
Thank you,
that would be
Elena.
great.
And you can call me John.
Thank you, John.
It feels too official with Mr. Birmingham. Like that's my dad. I'm not Mr. Birmingham.
Gotcha.
My dad's Mr. Birmingham. But
Gotcha.
thank you
Okay.
so much, everyone. And let me see if there's any questions.
Professor Birmingham, could you tell us a little bit about the case that you're working on now with the Native American water rights?
I can talk somewhat about it. Some of it's privileged, but it's basically homeowners who have archaeologists and investigators on their land. They own a farm. They have found artifacts that they believe are Native American in nature, and they're getting confirmation on that. And if the confirmation holds up, certain development going on in the township could come to a halt. So first, we're waiting to see on confirmation of the pieces of the artifacts that have been found and whether they are Native American ancestry. And then we determine from there, what do we do? But I will say this, if they are Native American ancestry, there's going to be such feedback from the people, don't develop there. I can tell you that right offhand because I talk to the people on a regular basis, and that's going to be the consensus in our township. Don't develop there.
Thank you. They must be pretty important artifacts, like something more than just arrowheads, I would take it.
They are, yes.
Thank you so much.
Thank you, Karen.
All right. And for anyone that needs CLE credit, please look in the chat room. I have posted the passcode. Please email me the passcode and request in order to request a copy of today's presentation, as well as the CLE certificate. Yes, Happy New Year, everyone. Thanks for joining us.
Happy New Year.